Hello, my name is Attorney Masa Sam Foray, founder of the Foray firm with offices in Chicago and in Houston, Texas. And I am back again today to talk to you about all things related to Illinois family law. So today's question is, my child's mother refuses to pay her child support on time. What can I do? So let me tell you, I'll repeat it once again, folks. Court orders are not suggestions and they are not requests. Therefore, they are not optional and they are mandatory. So if you have a situation where your child's mother is ordered to pay child support to you and she is failing to do so by the date in the child support order, then she could be held in contempt of court. So the first thing you need to do, especially if it's a situation that happens regularly and frequently, is to file what we call a petition for rule to show cause. That petition for rule to show cause for indirect civil contempt, otherwise known as a petition for rule, essentially tells a court that a court order has been entered and somebody is not in compliance with the court order, and you're asking for the court to hold them in contempt of court. In addition to filing a petition for rule to show cause for failure to pay child support flat out, you can also file a petition for rule to show cause for simple failure to comply with the pay date in your child support order. So for this particular example, because the question is, what can you do about your child's mother paying late or paying after the date that was listed in the child support order, know that you also have the remedy of a petition for rule to show cause at your disposal if she is not failing to pay altogether, but if she is consistently late. Because it's not fair to have somebody sit and wait to pay child support when it's convenient to them, and for you to have to make up the difference and support the children on your own in the meantime and not be able to rely upon consistent child support puts you and the children at a distinct disadvantage. So file your petition for rule. But in addition to filing the petition for rule to show cause, you can also submit a notice of withholding to the employer. So what that notice of withholding or notice to withhold does is it tells the employer, hey, you have an employee. This is a court order obligating that employee to pay child support to me, and I want you to withhold and garnish the wages on my behalf and then forward them on to the state disbursement unit so that I can get the money. Just like any other wage garnishment, an employer is obligated to comply with a notice of withholding and a lawfully entered child support order. So logistically, what you do is you complete the notice to withhold, you attach the child support order. There will literally be sections on the notice to withhold that you can fill out to give them all the options. You will complete the annual amount of child support. You will put the calculation on there for somebody who gets paid twice a month, maybe on the 1st and the 15th. You will put the calculation on there for somebody who gets paid bi-weekly, so perhaps every other Friday. And of course, you'll put the monthly amounts on there. So that means there's absolutely no excuse to the HR department or to the employer to not know the proper amount of child support to withhold. All they have to do is comply with the order, and all they have to do is enforce the notice of withholding. So that is a powerful, powerful tool for people who are just tired of waiting for late checks and late money orders to come in the mail. In addition to that, Illinois Healthcare and Family Services and the Department of Child Support Enforcement will assist any Illinois resident with enforcing a child support order. So what you could do is, if you had a judicially entered child support order, meaning it was entered by a judge, after you get that child support order entered by the judge, you can then enroll that judicial order with HFS. And HFS can then put them in the system. They will obviously charge a nominal annual fee for these services, but they will keep an accounting on your behalf. They will add on interest for any late payments. And by the way, if you are the obligor in a child support case, just know that there are 9% fees. So 9% interest per annum per year is tacked on to any arrearages for child support. And that's how people who pay late consistently continue to dig themselves into a deeper hole. So in any event, HFS will do this accounting for you so you don't have to be an accountant. And what they will eventually do as they audit their records is when they identify individuals who are consistently late on their child support, they'll start child support proceedings, child support enforcement proceedings that include filing a petition for rule to show cause, eventually asking for somebody's license to be suspended, for passports to be denied, and then of course for body attachments to be issued. So they're also a very powerful ally. And oftentimes when we go to court as practitioners and we ask for the entry of a child support order, we'll then enroll the order or tell our client to enroll the order with HFS so that HFS can then take it from there. So just know that you have any number of different options available to you. And if you have any questions about your rights and the obligations of the other person, not only to pay child support, but for her to pay child support in a timely fashion, definitely consult with a trusted family law attorney. I hope that this has been helpful and I look forward to seeing you on the next video.